What happened to the Todd Blanche who was a prosecutor in the Southern District of New York when he said that power doesn't corrupt as much as it reveals, and who you are is someone willing to sacrifice everything you once believed in for that title, for that position?
So I am the same Todd Blanche I was when I was a federal prosecutor in the SDNY.
Todd Blanche was Donald Trump's personal attorney in the New York hush money case, the Mar-a-Lago classified documents investigation, and the federal case related to the 2020 election. Now that same man wants to be the U.S. Attorney General. And at the July 15th hearing, Adam Schiff confronted him with the question he had been avoiding for months. Blanche says he has recused himself from certain cases involving his former client. But his signature is still on the IRS settlement covering Trump, his sons, and their companies. Moreover, the defenses the government could use against this settlement have never been presented to the court. That's why Schiff's question was quite simple. Where does Donald Trump's former attorney end, and where does the nation's attorney general begin? Watch this hearing. Subscribe to support the channel, like the video, and leave a comment.
Thank you, Mr. Chairman. Mr. Blanche, you represented the president in at least three criminal cases: the hush money payment case in New York, the January 6th case, and the Mar-a-Lago classified documents case. You said when you appeared last before this committee you would consult with ethics lawyers about that apparent conflict of interest in handling any case involving the president, having been his personal counsel. Did you consult with Joseph Terrell, a senior ethics lawyer at the department?
I believe I met with Mr. Terrell, yes.
Did Mr. Terrell tell you that ethics laws and policies required that you not be involved in cases involving your prior representation of the president?
Yes.
So in those three matters, the hush money payment case, January 6th case, Mar-a-Lago case, you were to recuse yourself?
I'm recused, correct. Well, by the way, the cases are not ongoing, Senator, but to the extent there's any work around those cases, yes, I'm recused.
So you said to CPAC a couple months ago, the other things that are happening, there is not a single man or woman at the Department of Justice who had anything to do with those prosecutions, meaning the prosecution of the president. So you're saying that it's not a conflict of interest for you to be involved in the firing of prosecutors who prosecuted your client, your former client? There's no conflict there? Is that
no, there is. I wasn't involved.
So
that would be a conflict.
At CPAC, you're taking credit for the firing of these Department of Justice lawyers, but you're not willing to take responsibility before this committee. Is that the case?
No.
Okay.
I'm making, there's a statement I gave at CPAC.
You were bragging about this at CPAC, the firing of these prosecutors, the firing of the FBI agents, the getting rid of everyone who investigated your client. You were proud of that, speaking for the Department of Justice, but you don't think that's a conflict of interest. You moved to vacate, I don't think you're going to deny involvement in this, you moved to vacate the convictions of 12 Proud Boys and Oath Keepers, which erased their convictions, restored their gun rights. These people were convicted in the January 6th investigation, which also involved the president, who you represented. You were involved in dismissing those cases, were you not?
I'm the acting attorney general, so yes, my department moved to dismiss. I was not involved.
So you didn't recuse yourself from that matter. You were willing.
There's no reason to, from the Proud Boys matter?
Yes,
I mean,
it was.
Lawyer, you know the rules. There are rules that say when I have to be recused, and that's not one of them.
And there are rules, and when you're told to recuse yourself from investigations that you handle for the president, you're supposed to recuse yourself.
No, when I represented the president.
You've also said, you've also refused to release Volume 2 of the Special Counsel's report. That was an investigation into the Mar-a-Lago documents case. How is that not an abundant conflict of interest? Refusing to release to the public an investigative report of an investigation into your client.
I am not a judge. A federal judge.
No. The department's position under you, Mr. Blanche, was do not release the report.
So that position.
If you went into court asking them to release it, it would be released by now. So how is that not a patent conflict of interest?
What you're saying happens to not be true. I did not do that. What you're talking about happened before I became the Deputy Attorney General. So you support the release of Volume 2? No, I don't, but I'm recused and had nothing to do with that case. Like, you can't accuse me of violating my ethical rules and then lie about what I did.
So you had nothing to do with the decision to prohibit the release of the report. You had nothing to do with the department's
wasn't in court.
position. No, I'm not asking whether you were in court. I'm asking you whether anyone sought your opinion or used your guidance in refusing to release Volume 2.
When
You're saying you had nothing to do with that decision?
Litigation was ongoing, I was a private citizen, still representing the President of the United States. It was before March. Since March, to the extent there's been anything in front of that judge,
Mr. Blanche, I asked you in your last confirmation hearing whether you would release the report, and your answer was no. Your answer was not, I will recuse myself. Your answer was no, I will not release the report. That was your testimony last before this committee. You subsequently were advised by ethics lawyers not to be involved in these matters, but it appears you were involved in these matters. Let me ask you about another matter.
I wasn't involved. Well, you can't say it appears I was involved when I said I wasn't.
Let me ask you about another one you have your name on.
The truth has to matter at some point.
Yeah, it does matter. We just don't hear much of it from you. But let me ask you about another matter you have your name on. I don't think you can deny responsibility here, and that is the IRS settlement agreement. So you put your name on this. That absolves the president of tax liabilities in the past. The president was convicted in the case you represented him in of falsifying business records in part for tax purposes. Does this settlement not absolve the president of any liability for tax crimes associated with what he's already been convicted of?
That's not what he was convicted of. Not having to do with tax purposes.
I'm happy to read the statement of facts. The participants took steps that mischaracterized for tax purposes the true nature of the payments made in furtherance of the scheme. So you know,
the
Mr. Blanche,
there was not the president. It was somebody else.
Well, if the president is conspiring with others to falsify business records to help them cheat on taxes, he is also exposed to liability. You know that as well as I do.
He can't be audited for that.
And of course he can be. Of course he can be. And he can be prosecuted for it. But the agreement you signed on behalf of your former client, on behalf of your current client, in a staggering example of self-dealing prohibits that. Let me ask you this. Does this tax agreement, this addendum you signed, also hold him harmless from any audit or tax liability with respect to the billions in crypto money he made in his first year as president?
It's not forward-looking. So to the extent there are taxes filed by the president or his sons or the Trump organization after the date of that agreement, there's no protection.
Well, but before that agreement. So any taxes,
he hasn't filed taxes yet for money he made last year, right? So
yes.
No.
So if he
no protection.
If he filed tax returns this year for money he earned last year, that his sons earned, that his World Liberty Financial, all those people earned and defrauded taxpayers on it, he faces no liability under this agreement you signed.
There's no evidence taxpayers were defrauded, and he is not protected.
There's evidence in this agreement that you've absolved him of any liability over.
No, I just said he's not absolved. So the question
So this agreement doesn't apply to a tax return filed last year or filed this year?
To tax returns filed after the date of the agreement? No,
No, before the agreement. A tax return filed in this calendar year before this agreement.
Before the agreement, it applies, not after.
Okay, so for a tax return filed this year for last year, for the billions he made, there's no tax liability even if he cheats on his taxes or his kids do or his business do. He is absolved of that further potential liability.
No.
Well, it's in the plain language of your agreement. Did you write this language?
You have to use the facts, though, that he hasn't filed taxes yet. So when he files taxes, there's no protection based upon this agreement.
Did you write this language?
Did I type it up myself?
Did you write this language?
No.
Well, you put your name to it.
I did.
So who wrote this?
I don't know the person that actually typed it. I don't know who it is.
Was it one of the president's lawyers, or was it someone from the Justice Department or IRS?
This document would have been somebody within the Department of Justice.
Well, you have no idea who that is.
I don't know the name of the person that typed it up.
And did you debate with them the statute of limitations, which clearly would preclude the president's claim, this $10 billion lawsuit?
We had extensive discussions internally about the underlying litigation.
And did you reject the statute of limitations defense?
I'm not a judge. I don't reject things.
But you signed an agreement for the U.S.
There was discussion around
you signed an agreement for the U.S. basically indicating that the Justice Department's position that the statute of limitations applies doesn't matter.
I did. That's not what I said. I didn't say that anywhere.
Who rejected the 25 defenses the IRS had to this sham lawsuit? Who rejected them? Who said that these defenses we're not going to accept, we're just going to go with the president's agreement in the slush fund, this immunity?
There was a lot of discussion internally.
But you made the decision.
What's the decision? What do you mean?
You made the decision to not defend the IRS and the Justice Department. You made the decision and said to sign this slush fund agreement.
We made the decision to settle the case, correct?
Yeah. And in doing that, you basically decided that you were going to be the lawyer for the president and the lawyer for the IRS and the Justice Department. As the court found in this case, there was no adversarial relationship.
Yes,
the court found it was a sham. It was a collusive relationship. And what I don't understand, Todd Blanche, what happened to the Todd Blanche who was a prosecutor in the Southern District of New York? What happened to the prosecutor people had respect for? What happened to the prosecutor who once respected the rule of law? What happened to the prosecutor who said that there wouldn't be a whiff of political partisanship and then prosecutes the president's enemies over Seychelles cases, over making a video stating the plain law and Constitution? What happened to the Todd Blanche of the Southern District of New York that could convert him into you, someone willing to say the president has both the right and the duty to prosecute his political enemies? I cannot imagine the Todd Blanche of the old days would have ever done that. What happened to you, Todd Blanche? I'll tell you this. I think Robert Caro had it right when he said that power doesn't corrupt as much as it reveals. I suspect it has just revealed who you are. And who you are is someone willing to sacrifice everything you once believed in for that title, for that position of Attorney General. And it is a sad story that we have seen from Trump appointee after appointee after appointee. We have seen people compromise themselves little by little and then a lot by a lot until they're sitting before this committee and trying to justify the unjustifiable. I yield back.
Okay. May I just briefly respond, Chairman?
Yes, you may.
Very briefly. So you asked me what happened to Todd Blanche. I am still here. I am the same exact person I was when I was a federal prosecutor in the SDNY, which is do the right thing and do everything you can to keep communities safe. So when I was a line prosecutor, when I was a supervisor, when I was the head of a division, my motivation and my goal was the same thing with the people who worked with me and worked for me, which is do the right thing, enforce the laws, and put bad guys in jail. And so you spend time talking about, I did not interrupt you. I did not interrupt you. A little courtesy would be appropriate. So when you ask me what has changed, okay, and you talk about a single document that I signed, okay, and somebody had to sign that document when the president sued, okay, so I tried to do the right thing. What I do every single day, and what the prosecutors in this country do every single day, and the nearly 100,000 indictments and informations that have been filed since January 20th, is exactly what everybody in this building should want the Department of Justice to do, which is to make our communities safer, enforce the laws, both civilly and criminally, and always do the right thing with integrity, which is exactly what I'm doing. So I am the same Todd Blanche I was when I was a federal prosecutor in the SDNY.
All right, let's start with Blanche's most striking response. Someone, he said, had to sign that document. He said it as if a routine piece of paperwork had landed on his desk and he had simply signed his name on the dotted line. But Schiff wasn't asking him who physically drafted the document. He was asking who made that decision on behalf of the government, who decided which defenses the IRS would drop, who agreed to close out which tax matters involving Trump and his companies. And why was the person who signed this agreement the personal attorney of the very man who had benefited from it just a short time before? Because we're not talking about a mere possibility of a conflict of interest here. Trump, his sons, and the Trump Organization filed a $10 billion lawsuit against the IRS and the Department of the Treasury. On one side of the case was Trump's private legal team. On the other side was the federal government, headed by Trump himself. And the person leading the Department of Justice, which was supposed to defend that government in court, was Trump's former criminal defense attorney. And in the end, the person who signed on behalf of the government was once again Todd Blanche. There's no need to overcomplicate this situation. Your former client is suing the government, you're the government's top legal official, and you're the one signing the settlement on its behalf. Now, don't think this proceeded like a normal lawsuit. The federal government had numerous defenses it could have used against Trump's claims. Schiff said in the hearing that these were grouped under 25 separate headings. The statute of limitations was just one of them. Normally, the Department of Justice presents these defenses to the court, Trump's lawyers respond, and a judge decides who is right. That didn't happen here. The government didn't defend its own tax agency. The defenses weren't tested in court. Then the parties reached a settlement. When Blanche was asked who made the decision not to use these defenses, he shot back by asking which decision Schiff even meant, but there was nothing ambiguous about it. The decision was not to bring the IRS's defenses before the court. The decision was to settle rather than fight Trump's $10 billion claim. Schiff asked about this in several different ways. Blanche said there were numerous internal discussions, but he did not say who made the final decision. So we don't know why the government didn't mount a defense. We don't know who drafted the document, but we do know whose name is on it. And 2 days before the hearing, federal judge Kathleen Williams reviewed this very document. The judge concluded that there were not in any real sense two opposing sides in the case. Instead, she said the court was being used to legitimize an agreement that provided protection to Trump and the individuals and companies associated with him. She also prohibited the parties from using this agreement as a valid settlement in any future official proceedings. This was not Schiff's political interpretation. It was the conclusion reached in the federal court's 56-page ruling. Now look at the timing. While Trump's case was pending in federal court, the government failed to file a substantive defense for a long time. The judge began to question whether there was actually a dispute to be resolved. She asked the parties to clarify this. Then the settlement was announced, Trump agreed to drop the case, and a $1,776 million fund was established. The same settlement also included separate tax protection for Trump and his family. While the court was still asking whether there were really two opposing sides, the parties were already moving toward the same outcome. That's why the response, someone had to sign it, explains nothing. Yes, someone had to sign it, but weren't there other senior officials at the Department of Justice who had never represented Trump? Couldn't the case have been assigned to an independent team? If Blanche recused himself from criminal cases involving Trump, why wasn't the same ethical rule applied in this case? None of these questions were answered. It was handled as if Todd Blanche were the only official at the Department of Justice who could have signed anything at all. Furthermore, the scope of the tax order was not insignificant. The text used extremely broad language to shield Trump, his sons, and the Trump Organization from certain past tax claims and audits. It stated that the government was permanently barred from pursuing certain actions. Blanche had previously argued that this was not immunity, but merely a promise. But the choice of words here does not change the outcome. The government is agreeing in writing not to pursue certain actions related to Trump and his companies. Call it a promise, a waiver, or protection. The result is the same. And the person who signed this was no ordinary Justice Department official. He was the person who defended Trump in the New York hush money case, served on the legal team in the Mar-a-Lago documents investigation, and stood by his side in the federal election case. Blanche has no reason to be ashamed of this relationship. A defense attorney's job is to defend their client. The problem is that the decisions he made on behalf of the government after leaving that role continue to benefit that same former client. Schiff's questions regarding the special counsel's report also centered on this point. Blanche stated that he had recused himself from the case file related to the Mar-a-Lago investigation. However, when Schiff asked whether his opinion had been taken into account in the decision not to release the second part of the report, Blanche said only that he wasn't in court. Once again, he answered only the narrowest part of the question. Schiff wasn't asking him whether he was sitting in the courtroom. He was asking whether he had influenced the department's position. Did you have a phone conversation? Did you express an opinion at a meeting? Did the staff under you take into account the position you had previously stated? Saying he wasn't in court answers none of these questions. The same pattern emerged in the matter of the prosecutor's dismissal. Blanche said he did not participate in the decision to remove the prosecutors investigating Trump and acknowledged that if he had, it would have constituted a conflict of interest. This is actually a significant admission. It means that deciding the fate of those investigating your former client creates an ethical problem. So why doesn't signing a settlement on behalf of the government in a multi-billion-dollar tax case involving your former client create the same problem? Blanche did not explain this distinction. When asked about the convictions of Proud Boys and Oath Keepers members in the January 6 cases, he gave a different answer. He was acting attorney general at the time and acknowledged that his department had taken steps to reduce the sentences. So in one case, he wasn't involved. In another, he recused himself. In a third, the department made the decision. In a fourth, his own signature is on the document. Each answer on its own may have been carefully crafted, but when you put them all side by side, you don't see a consistent line. In which Trump case is Blanche truly stepping aside? In which case is he merely defending the outcome? In which case is he personally making the decision? This is why Schiff ultimately asked what had happened to Todd Blanche. This wasn't just a pointed closing remark. He was trying to highlight the contrast between the reputation Blanche had as a federal prosecutor in the past and the decisions he's defending today. Blanche answered that he was still here, still the same person. He said he's still trying to do the right thing, enforcing the law and putting bad people in jail. But Schiff wasn't asking how he saw himself. He wanted him to explain the records before him, because saying you have good intentions doesn't eliminate a conflict of interest. Saying you did the right thing doesn't explain why you didn't recuse yourself from your former client's case. Saying someone had to sign it doesn't answer why that person had to be you. And saying you weren't in court doesn't prove you had no influence on the department's decision. Now, let's take a step back and consider what this means. The Attorney General's independence isn't measured solely by whether he says no to the president when the president issues an unlawful order. The tougher test is whether you conflated the president's interests with those of the state before the president even explicitly asked for anything. If you've defended a former client for years, they may not even need to call you to understand what they want. That's exactly why ethical rules exist. Rather than trusting that an official is honest, they remove them from a case where their past relationship could influence their decisions. Blanche says he followed this rule in some cases, but he didn't follow it in one of the most important examples. He did not recuse himself from Trump's IRS case. The government's defenses were not presented to the court. A settlement was signed. Broad tax protection was established for Trump and his companies, and the person who approved this on behalf of the government was Trump's former personal attorney. Subsequently, a federal judge noted that the parties' interests were not actually in conflict, that the case had been used to benefit Trump and his allies, and barred the settlement from being used in the future. If we had to summarize the entire debate at the hearing in a single sentence, this is the issue. Blanche is the head of the Department of Justice when authority is exercised, but when held accountable, he distances himself from the decision. He signs the document, yet claims not to know who drafted it. The department takes action, yet he claims he was not involved. He says he recused himself from a case, yet he had previously expressed a clear opinion on the outcome of that very case. And this isn't just a debate about the Attorney General nominee's past. If confirmed, the same question will resurface in every future Trump investigation, every case against a political rival, and every decision where the president's personal interests intersect with those of the government. Whose lawyer is Todd Blanche? Blanche said he was still here, and in a literal sense, he is. But what Adam Schiff demonstrated in 5 minutes was that the real question wasn't whether he had changed. The real question was whether he had truly stepped down as Donald Trump's personal attorney. By the end of the hearing, there was still no answer to that question. Which answer do you think mattered most in this questioning? Was it when he said he wasn't in court, when he claimed he didn't know who wrote the document, or his defense that someone had to sign it? Share your thoughts in the comments. If you found the video helpful, don't forget to like it and subscribe to the channel for new hearing analyses.